Okay, I think we're getting there. People are filtering in nicely. And in the interest of timekeeping, so we can get to conversations and make sure we hear enough of that we can from Mark as well. I'm going to start. Good afternoon, everyone. Welcome to another session of Outside In. My name is Matthew Rice. I'm a Principal Policy Advisor in the Information Commissioner's Office, working in our Regulatory Risk and Innovation Directorate. For those of you joining us for the first time, the Outside In is a series of events where external speakers come to talk to us about things that relate to our work or the way that we work. We've also got colleagues joining from across the Digital Regulation Cooperation Forum, so welcome, welcome, and thanks for coming along. The eagle-eyed amongst you may notice that I look like I'm sitting in a car. That's because I am. Full disclosure, I'm on the school run, so I will be here to introduce yourselves and introduce Mark, but I'm going to have to drop off for a moment, then I'll come back. In doing so, I'm going to be handing over to a kind of co-host in this, and our resident neurotech expert, Robert McComb, who I'll let him introduce himself now, and then I'll introduce Mark. Go ahead, Rob.
Thanks, Matt, and afternoon, everyone. As you'll have gathered, I'm Rob McComb. I'm the Principal Policy Advisor for the ICO's Emerging Technologies team. We look to provide a key part of the horizon scanning function. My work on neurotech stretches all the way back to 2022 with one of the early Tech Futures papers focusing on neurotech and its privacy and data protection implications. That work's continued with further work with the European Berlin Group, ongoing research and engagement with stakeholders, and currently working with team members to build and develop public guidance on neurotech, which is running alongside the Regulatory Pioneers funding grant that we received for public and industry engagement in the area. So very much looking forward to this afternoon's talk, and back to you, Matt.
Brilliant. Thanks, Rob. So over to our speaker. Today, we've got the great honour of welcoming Dr. Mark Leiser. Mark is a leading expert in platform regulation and a recognised voice on the emerging frontier of AI and neurotechnology. He's published extensively on the intersection of law, technology and behavioural design, and today's discussion is going to focus on the profound effects of what happens when AI systems are trained using neurodata. I'm going to hand over to you, Mark. Enjoy.
Thanks, Matthew, and thanks for having me here today. It's a privilege and an honor. I want to start with a structural claim just to kind of set the scene rather than a technological one. So the European and the UK data protection frameworks were built on an assumption that the regulation concerns information about people. I know that sounds oversimplistic, but it's just an assumption I want to start with. So what I'm going to talk about today, Neuro AI, challenges that assumption by modeling the processes through which people think. Now, the move from data to cognition protection is not rhetorical. It describes a shift in the object of regulation. Historically, regulators have governed what is collected, stored, shared, decided. The unit of analysis has always been the data processing event. What is emerging now are systems that can model deliberation itself, whether that's attention, affect, susceptibility, and intention, before any legally cognizable decision has actually occurred. I want to be clear that this is not a story about brain implants or science fiction. It's a story about machine learning systems trained on neurodata that comes from neurotechnologies, or proxies calibrated to what I call neural ground truth. So when behavioral data that we work with and concentrate on now is trained against neural benchmarks, it acquires a cognitive dimension, and that is the inflection point. The regulatory difficulty is temporal. The frameworks you work with, lawfulness, fairness, purpose limitation, automated decision-making, they presuppose a downstream moment of impact. Neuro AI shifts impact to the upstream pre-decisional layer. And this is the terrain I want to map today. So, as Matthew said, I started working on deceptive design, and many of you would refer to that as dark patterns. and the limits of regulating interface manipulation. And in that context, the harm is visible: nudging, friction, misdirection. The intervention occurs at the level of choice architecture. I think the CMA has an online choice architecture moniker, which they refer to as an example of that. As it happened, towards the last chapter of the Dark Patterns book, I was given an opportunity to play around with what is referred to as a large action model. And a large action model is not to be confused with a large language model. And I'll explain what I mean in a little bit of time, or a couple of slides. But as I examined large action models, I realized something had changed. LAMs do not merely generate content. They learn workflows, and they execute goal-directed sequences across systems. So they end up collapsing the gap between intention and execution. And this was the first indication that AI was no longer simply predicting behavior, but actually operationalizing it. So neuro AI is the next shift. It's not about acting on the user's behalf like agentic AI. It's about modeling the cognitive substrate through which the user forms intention in the first place. This is a qualitatively different regulatory object. So I use the term neuro AI not to dramatize, but to categorize. It marks a form of modeling which is trained either on neurodata coming from neurotech, or indirectly on behavioral proxies grounded in neural correlation. It captures systems that do not merely observe behavior, but infer cognitive states before there's been an expression. So the through line in my work is this: regulatory frameworks assume a distinction between internal cognition and external conduct. That distinction is collapsing under the pressure of computational modeling. The rest of the talk that I give today is going to examine the consequences of that collapse. So I want to compare and contrast large action models with large language models for a second. So let me briefly anchor this transition. Large action models are not the same as LLMs. LAMs are not response systems. They are goal-driven systems. They do not predict text. They learn how tasks unfold across digital environments. They model the sequences through which humans achieve objectives and autonomously replicate them. This matters because it introduces agency-like behavior into software systems. The model does not merely suggest what you might do, it acts within defined constraints to pursue an objective. The human sets the direction, the system handles execution. So let me give you a kind of positive example of an LLM in the wild, so to speak. Imagine a large online retailer deploying a large action model to manage post-purchase customer service. Instead of programming fixed workflows or relying on scripted chatbots, the company trains a model on millions of past customer interactions, return processes, delivery issues, refund pathways. The LAM doesn't just generate responses, that's a chatbot. A LAM learns the sequence of steps humans take to resolve problems: verifying the identity, checking inventory systems, initiating courier pickups, processing refunds, updating logistics platforms. When a new customer contacts support, the system interprets the goal, such as "my parcel never arrived," and then autonomously executes the necessary actions across their own internal systems. It logs into shipping databases. It triggers replacement dispatch. It issues refund authorization and sends confirmation emails without waiting for a human to intervene. For someone new to this, the key distinction is that traditional AI might suggest what to do or draft a reply. A large action model carries out the steps necessary to achieve the objective. It moves from predicting language to performing coordinated tasks across digital environments. Now, let me give you a darker example of a LAM and how it might be deployed. So imagine a dominant financial services platform using a LAM trained not on just transaction histories, but on years of behavioral telemetry, how long users hover over loan offers, how they scroll through terms and conditions, when they tend to abandon applications, how their interaction speed changes late at night, how their spending spikes after salary deposits, and how micro delays correlate with hesitation. The model is not instructed to deceive. It is instructed to maximize uptake of premium credit products within acceptable risk thresholds. When a user logs in, the LAM does not merely display offers anymore. It predicts in real time their cognitive state, fatigue, urgency, susceptibility to scarcity cues. It recognizes that this particular user is most influenceable shortly after midnight, when attentional stability drops and impulse control weakens. The interface subtly shifts. The repayment example defaults to a lower monthly figure with a longer term. The accept button appears fractionally sooner in the scroll flow. Alternative options are still present, but placed just far enough down the page that most users don't reach them. If the user hesitates, the model introduces a time-limited banner calibrated to trigger loss aversion at precisely the moment when hesitation typically resolves into abandonment. No one lies, no information is falsified, consent is technically obtained. The system executes what it has learned about how decisions form under cognitive strain. From the outside, this looks like optimization. From the inside, it's something more troubling. The model is not overriding the user's will. It is shaping the conditions under which that will operates. It anticipates vulnerability and times intervention accordingly. The user believes that they are making a choice. In reality, the environment has been orchestrated to narrow the path along which that choice unfolds. This is where autonomy erodes without spectacle. There is no coercion. There is no explicit pressure, no visible manipulation. There's only a system that has learned the rhythms of deliberation and deploys them. The harm does not appear at the moment of decision. It lies in the pre-structuring of the cognitive space in which the decision becomes thinkable at all. That shift strains regulatory categories. When AI executes rather than recommends, we move from content into conduct governance. Responsibility, foreseeability, autonomy, control become considerably more complex. So LAMs still operate at the behavioral layer. They model how people achieve a goal. Neuro AI, on the other hand, moves one step further upstream. Instead of modeling task execution, it models how deliberation actually unfolds, how attention fluctuates, how emotional resonance shapes preference, and how hesitation correlates with later decision pathways. So if LAMs convert intention into execution, Neuro AI models the formation of intention. And that pivot from action to cognition is where the regulatory architecture of our data protection and AI regimes, if you're a European, actually begin to thin. Next slide. So at this point, I want to introduce this kind of definitional anchor. When I use the term neuro AI, I'm not referring to a device category. It's not limited to a brain implant or a medical scanner or fMRI or experimental neurotechnology. It's not a sector. It's not a marketing term. It's a functional definition. So in my book, I define NeuroAI as an AI system which is trained directly on neural data or indirectly on behavioral or psychological proxies calibrated against neural ground truth, which then model and act upon the cognitive processes. The key shift is not the sensor, it's the modeling objective. LAMs learn tasks. NeuroAI learns cognition. Specifically, it learns patterns in attention, in affect, in susceptibility, in hesitation, in cognitive load, and pre-decisional orientation. Once trained, it can deploy inferences to adjust the environment, to sequence information, to time interventions, or to prioritize outputs. The distinction is temporal. Behavioral AI predicts what somebody has done or is likely to do based upon observable patterns. NeuroAI predicts how deliberation is unfolding before a choice has been finalized. This shift matters because most regulatory frameworks assume that intervention occurs after an externalized act, a click, a statement, a transaction. NeuroAI operates before, NeuroAI operates before that externalization. It sits in the pre-decisional layer where agency is actually formed. So this is why I argue that NeuroAI actually constitutes a different modeling category. Not because it's more dramatic, but because it collapses the boundary between internal cognition and external behaviors in ways that existing doctrine can't actually anticipate or hasn't actually anticipated. So let me give you a very quick example of how NeuroAI might operate in practice. Imagine a social media platform deploying a NeuroAI system trained on a combination of neural calibration datasets. So you've got this research context, billions of behavioral proxies. So you've got gaze fixation from AR filters, you've got scroll velocity, you've got micro pauses before sharing, you've got voice inflection in recorded stories, you've got typing latency in comment fields. The system is trained to map these signals onto latent cognitive states like fatigue or emotional volatility, or susceptible to outrage, reward sensitivity, or attentional depletion. So I want to be clear to avoid the science fiction label. It does not read thoughts. It does not implant ideas. It does not override choice. Instead, it predicts in this context when deliberation is weakest. So when a user logs in late at night, the system detects elevated emotional reactivity and reduced executive control. It adjusts the feed accordingly. Content that is statistically more likely to trigger a rapid, effective response is surfaced slightly earlier. Friction for resharing is subtly reduced. Countervailing content is not removed. It is merely delayed by a few seconds in the ranking cascade. The model has learned that under these cognitive conditions for this particular user, hesitation correlates with viral amplification. The user doesn't experience any of this as interference. They experience a compelling stream of material that feels aligned with how they are already feeling. They decide to reshare. They comment. They escalate tone. They believe they're exercising preference. But behind the scenes, the system is continuously recalibrating. If the user hesitates, it introduces cues associated with urgency or social validation. If arousal declines, it ejects a higher valence of stimuli. Each adjustment is minute. No single intervention causes a threshold which would qualify as manipulation under existing law. No data is misused. No decision with legal effect has occurred. Yet over time, the user's cognitive environment, the environment in which they make decisions, narrows. Emotional states are reinforced and validated in moments of vulnerability. Attention is trained towards polarizing stimuli. Deliberation becomes more reactive and less reflective. The platform does not dictate belief. It optimizes the conditions under which belief is forming. This is purely neural AI. No direct neural capture at the point of use, no coercion, no deception, no unlawful processing event. The harm lies in the modeling objective itself, to infer pre-decisional states and operationalize them through adaptive feedback loops. From a regulatory perspective, nothing dramatic has happened. From an autonomy perspective, something profound has actually shifted. Influence is not waiting for behavior to appear. It's actually anticipating the cognition and restructuring the environment that matches the cognitive state. This is the dark side of neuro AI deployment. So if AI begins to model cognition rather than behavior, several things change simultaneously. First, the object of prediction shifts. The system is no longer correlating past actions. It's mapping trajectories of deliberation. That means that the most relevant signals are not the final decision, but the microdynamics that precede it. So the fluctuations in attention, the response latency, emotional resonance, hesitation patterns. Second, the timing of influence shifts. The traditional regulatory logic of the GDPR data laws is decision-centric. Harm is assessed at the point of outcome, a loan refusal, a price differentiation, a ranking result. When AI models cognition, intervention can occur before the decision exists. The environment can be calibrated at the moment of maximum susceptibility, long before any legally cognizable event. Third, the structure of feedback changes. Behavioral systems produce discrete outputs. Cognitive modeling operates in loops. Signals generate inference. Inference shapes the environment. The reshaped environment generates new signals. The iterative feedback produces a form of conditioning rather than a single actionable event. Fourth, the risk profile changes. The concern is no longer solely the misuse of data, it is shaping deliberative conditions. That's harder to detect, harder to contest, because the individual experiences the outcome as their own decision. And finally, any analysis of autonomy. Our legal frameworks are calibrated to visible interference. We talk about coercion, discrimination, misinformation, unlawful processing. Cognitive modeling can operate without any of these. It can remain formally compliant under our laws while substantively altering the chosen architecture. So the regulatory question, therefore, moves upstream. It is not only was the data processed lawfully, it is should this form of inference have been pursued at all? And that's basically what I'm going to cover over the duration of the talk that I have. So what is Neurodata and why it matters? What is Neurodata? I think it's important to talk about Neurodata through the lens of precision. The term should not be reserved for brain implants or laboratory imaging, nor should it be diluted into a catch-all for sensitive behavioral data. It describes signals that reveal cognition. And for me, there's three technical entry points. The first is neural signals, EEG, neuroimaging, implant-based recordings, increasingly lower fidelity, consumer devices. These are the clearest cases. They record electrical or metabolic activity in the brain. In the UK GDPR, these would typically qualify as personal data, and where health or biometric implications arise, as special category data. But the regulatory difficulty is not classification alone. It's that these signals expose mental states, not just health conditions, but you can map intention, you can map affect, you can map recognition, and you can literally datify salience. The second layer consists of psychological proxies, so gaze fixation, pupil dilation, galvanic skin response, heart rate variability, respiratory patterns. These are not inherently neural in origin, but when calibrated against neural ground truth during training, they become reliable indicators of cognitive processes. A gaze pattern ceases to be merely behavioral telemetry. It becomes a correlation of attention orientation. A change in microvariance becomes an index of affective shift. The third layer concerns behavioral micropatterns, cursor movements, if you're fidgety with your mouse, scroll hesitation, pauses before confirming a transaction, the tempo of typing. These signals look ordinary, but once models are trained on these data sets that connect such patterns to neural measurements, they inherit cognitive meaning. The behavioral trace becomes a proxy for these pre-decisional states. This layered structure matters legally because of the sensitivity of neurodata does not inherent the input. It emerges from the model's inferential architecture. The same behavioral signal may be trivial in one context and cognitively revealing in another, depending on how it has been trained and deployed. This strains our regulatory taxonomy. The UK GDPR and the DPA classify by data type. Neuro AI forces us to think functionality. Does this signal enable the reliable inference of mental states? If so, it operates as neurodata regardless of its origin. And once behavior becomes a proxy for cognition, data protection logic risks becoming insufficient. The regulatory question is no longer solely about information flows. It's about the modeling of the actual mental process. So where does the legal model begin to strain? This is the structural tension. Our data protection framework is orientated around three anchor points: data, processing events, and decisions. Harm is generally assessed at the point of outcome: refusal, ranking, pricing, exclusion, or profiling. That architecture assumes that cognition remains internal and inaccessible. Regulation focuses on what happens once cognition has been externalized into behavior or data. Neuro AI alters the timing of the regulatory relevance. By the time the legal threshold engages, whether that's fairness, transparency, safeguards for automated decision-making, or significant effect, cognitive modeling has already reshaped the decision environment. The intervention does not occur at the moment of the decision. It occurs at the stage where deliberation is actually unfolding. So I want to be clear, this isn't a claim that the law is defective. It is a claim about the orientation of the law. The GDPR governs processing. Article 22 applies to automated decisions that produce legal or similarly significant effects. But the most consequential modeling occurs before the decision exists. So the doctrinal trigger has nothing to actually attach to. Similarly, legitimate interest balancing assesses identifiable purposes against foreseeable impacts. But cognitive modeling may alter the susceptibility before any measurable impact can be demonstrated. So the issue is therefore temporal and structural. Our frameworks presuppose observable outputs. Neuro AI operates in the pre-decisional inference layer. That's why I described the challenge as architectural rather than technological at the start of this presentation. It's not that AI has become more powerful, it's that the locus of interference has shifted upstream into cognition itself. The legal model begins to strain, not because it's wrong, it's because it was calibrated for a world in which the mind was functionally opaque. That opacity is eroding. Now, one of the things that I did for your counterparts in France at CNIL was I made a reference to legitimate interest and whether their guidance on legitimate interest and the way that we handle AI programming was sufficient. And I'd like to just revisit that very quickly because I think it's one of the most flexible and powerful tools in the UK GDPR as well. It's also one of the most misunderstood aspects of emerging AI systems. Now, the legitimate interest test is structured around three familiar questions to us. Is there a legitimate aim? Is the processing necessary? And does the balance favor the controller or the data subject? That architecture, those three questions, presumes that we are balancing identifiable purposes against foreseeable impacts arising from processing events. Neuro AI actually complicates this structure in two ways. First, inference operates upstream of observable harm. The most consequential modeling may not produce a discrete outcome at all. It may instead reshape the informational and cognitive environment in which decisions later emerge. At that stage, it's difficult to point to a measurable impact that may be weighed in the balancing test. Second, procedural safeguards assess processing. They look at collection, they look at retention, they look at minimization, they look at transparency and opt-outs. The Neuro AI's core risk sits in the modeling objective. What is the system designed to infer, not merely in how the data is handled? This means a controller can satisfy formal procedural safeguards while still deploying a model that targets pre-decisional cognitive states. The issue, therefore, is not legality in the narrow sense. It is in structural reach. Legitimate interest balancing was designed for data events. Neuro AI shifts the locus of interference into the modeling layer itself. So the question then becomes for a regulator, should certain inferential objectives be considered presumptively incompatible with fairness, even when the underlying data collection appears lawful? This is not a revolution, it's a reframing of where the balancing exercise is actually situated. So if we accept that Neuro AI shifts influence upstream, there's kind of three frontiers emerge. The first is classification by function. So current frameworks classify data by type, so biometric, health, behavioral, special category. Neuro AI destabilizes this because sensitivity attaches to what the model reveals rather than the law signal. A typing cadence may appear innocuous until it becomes a reliable predictor of cognitive decline or susceptibility. This suggests a functional approach. When modeling reliably reveals cognitive states, the processing should attract heightened scrutiny regardless of the input category. The second frontier is governance of inference itself. Data protection law is input-centric. It regulates collection and processing. NeuroAI's most significant risks arise from the inferences drawn, even when the underlying data is lawfully obtained. The legitimacy of modeling objectives must therefore be examined. Not every inference that can be generated should necessarily be generated. This moves us into an inference legitimacy analysis. Is it fair, proportionate, and socially acceptable to model this cognitive state for this purpose? And the third frontier is the recognition of cognitive harm. Current regulatory triggers often require observable impact: discrimination, exclusion, financial loss, safety risk. Cognitive interference may not manifest in those forms immediately. It may instead narrow deliberative capacity. It may increase susceptibility, or it may reshape salience over time. The harm is not a single event, it's environmental conditioning. So if regulators do not recognize cognitive interference as a distinct category of risk, NeuroAI will remain formally compliant while substantively transformative behind the scenes in ways that we haven't imagined or could fully appreciate. So what is the object of protection? Up to this point, I've discussed modeling, inference, regulatory strain. But we now need to be clear about what is actually at stake. The central issue is not informational disclosure. It's not about giving people terms and conditions. It's not about merely profiling. And it's not about discrimination or the transparency principle. The object of protection is the integrity of the cognitive process itself when transparency is provided in order to obtain consent. If that decision-making is actually altered, then consent becomes completely, it lacks the integrity that the data protection framework is designed around. The object of protection is the integrity of the process. Our frameworks are built to govern information about individuals. The processes through which individuals form the intention is what NeuroAI is actually shifting the locus of risk into. This distinction matters. If a system predicts that I am likely to default on a loan, that is a behavioral forecast. If the system predicts that the moment at which my attentional stability drops and adjusts its environment accordingly, that is cognitive conditioning. NeuroAI operates on attention allocation, effective calibration, susceptibility to influence, a pre-decisional orientation. It does not need to override choice. It only needs to shape the conditions under which choice emerges. That's why the harm is not extraction. It's an environmental conditioning before the deliberation. The challenge is that our frameworks that protect informational, reputational, economic, and decisional autonomy, but they rarely conceptualize inference with the substrate of deliberation itself. And that risk is subtle, a narrowing of the cognitive field within which agency is exercised. If we misidentify the object of protection, every downstream safeguard will be misaligned. Now, if cognition becomes modeled at scale, it ceases to be merely private. It becomes infrastructural. And we already treat certain domains as infrastructural because they structure possibilities. Energy grids, financial systems, telecommunications. NeuroAI introduces a similar phenomenon, an epistemic infrastructure that shapes how populations attend, evaluate, and decide. that boundary between data and cognition is eroding. Once behavioral proxies are calibrated against neural benchmarks, modeling shifts from describing behavior to shaping deliberation. And the question, therefore, becomes, what do we do with our regulatory models that are centered solely on information flows that do not capture inference-driven conditioning? That question, as I said before, is not technological, it's structural. How much cognitive shaping are we going to allow our legal order to tolerate? That's not a requirement that we need new rights. It's a call to interpret existing principles like fairness, necessity, proportionality in light of modeling objectives rather than merely processing events. If inference becomes infrastructural, then the regulatory posture must also evolve from reactive oversight to anticipatory scrutiny. The challenge is not to ban these systems, but to define the outer boundary of permissive cognitive modeling. Now, let me end. Large action models execute tasks. Neuro AI models deliberation. Traditional regulation attaches to data and decisions. Neuro AI shifts influence upstream. The frameworks are not obsolete, but their orientation is downstream. So the regulatory question is whether inference into pre-decisional cognition is treated as just another form of profiling or a distinct site of interference requiring principled limits. And the mind has long been treated from human rights frameworks as inaccessible by default. And neuro AI now renders certain aspects inferable by design. And whether that inferability becomes normalized or bounded, that's not a technical question. That's a regulatory choice for anybody working in this space. I have submitted my final manuscript yesterday for my new book, which I cover all of this, called Artificial Intelligence, Neurodata and Society, Law at the Edge of Cognition. And I hope you will at least consider the pre-order of that book, which should be available by the end of the summer and the beginning of the autumn. Thank you very much for having me, and I'll turn it back over to our host for some questions and moderation. Thank you.